Most data breaches are caused by insiders as opposed to outside attackers. By insiders, I mean people who already have access to your system. That includes current employees, former employees who retain access rights to your system, and potentially third-party contractors or vendors who you have granted access to your system. The reason why insiders cause more data breaches than outside hackers is that most systems have a fairly high degree of protection and security. And it does take some time and effort for an outside attacker to get into your system through a firewall, for example. Whereas the insiders, by definition, are already in your system. There are current employees and former employees who may have retained access who have a motive to cause a data breach. There are disgruntled employees in every organization. In every organization, there are likely employees who are about to leave to go to a competitor and have a reason to take information with them to compete with you. Regulation in this area is evolving toward restricting the use of non-compete agreements and in favoring the rights of individuals. For example, Massachusetts recently passed a law with the intention to limit the use of non-compete agreements in certain situations. Illinois passed a law recently prohibiting the use of non-compete agreements with regard to lower wage workers. And in certain jurisdictions, such as the Northern District of Illinois, there have been recent decisions throwing out claims attempting to enforce overbroad non-compete agreements without giving the plaintiffs any opportunity to argue for modification or a narrowing of the restrictions. The trend among both legislatures and in courts across the country is to limit enforcement of non-compete agreements.